next case to come before the court is the U.S.D.A. versus Myers. Each will have 15 minutes. You may save up to 5 minutes for rebuttal as the appellant. And we're ready to proceed.
May it please the court, counsel. My name is Rebecca Smith. I am the attorney for the United States of America Department of Agriculture, who is the appellant in this case. The case comes down to an issue about the authentication of a mortgage in a foreclosure case. There were several objections to the mortgage that was presented at the trial, one being hearsay, one being that it was not a certified copy of the mortgage, and finally that it was in fact a duplicate and not the original of the mortgage. As to the hearsay objection, obviously hearsay should be excluded as evidence in any trial when it is presented for the truth of the matter asserted. However, as we all know, there are multiple exceptions to hearsay. There's the public document or public record hearsay exception, there's the business record, and then there's those records that pertain to interest in real estate. And in this case, the mortgage hits all three of those. Obviously, a mortgage is evidence of the securitization of a promissory note on property. It is a record created in the normal course of business, and it's a recorded document, so it's a public record. So for all of those three reasons, it should be accepted as a hearsay exception. As far as self-authenticating documents go, documents need to be authenticated, but the courts have found through the evidence rules that some documents are self-authenticating. One of those is certified public documents.
Was this a certified?
It was not. But a little bit farther down in 9028, evidence rule 9028, self-authentication can also occur when it is acknowledged by a notary. At no point in the trial was there a question as to that acknowledgement, a question as to the signatures of either the notary or the parties.
The only problem I have with that is, sure, as a notary acknowledgement, but the whole point isn't the whole point of a notary acknowledgement is it's original, and this was a copy, right?
It was a copy. However, going to the question of the duplicate, when a duplicate is presented, the court is allowed to accept a duplicate in lieu of the original if two conditions fail to exist, and one is a genuine question as to the authenticity of the duplicate, and that was never raised, and whether or not it would be genuinely unfair to accept the duplicate in lieu of the original. And again, that is not a question in this case. So,
But is that but that rule doesn't really apply, does it, to a document that needs to be notarized to begin with? In other words, so you have a contract, and nobody can find the original contract, and nobody's disagreeing that the copy of the contract is not authentic. I think the rule would provide that obviously that could be admitted, but if it's a marriage license and needs to be notarized or filed with the court or whatever, and you just have a copy of that, you're arguing that's the same thing.
Again, I'm arguing that a duplicate should be granted if there's no question as to the authenticity of that document, and in here there wasn't.
But they objected, didn't they?
Not to the authenticity of the document. They objected based on hearsay. They objected that it wasn't a certified copy, and I agree with it wasn't a certified copy. Clearly, I could have saved
I
myself.
thought they also objected that it was a duplicate.
The judge did in his final decision.
I know, but I thought he also said
trial
in one of the briefs, and we haven't read the record yet, we'll do that. But I thought one of the arguments from the appellee was that they had also objected that it was a duplicate.
Not in so many words. There was a question during the trial as to my client's ability, based on education, training, and experience, to testify as to the mortgage, but it wasn't about the authenticity of the mortgage itself. That was never brought up in trial. The appellee's argument in his brief mentioned that it was denied in the answer, but again, no specific question as to the authenticity of the document itself. The objections focused on the fact that it wasn't a certified copy, and again, the hearsay objection, which I've already addressed. As far as self-authenticating, like I said, I can argue that the notary signature makes it a self-authenticating document. And clearly, I would argue that it would not be unfair to accept the duplicate in this case because the way this case is left is an unsecured debt of a promissory note with no mortgage to secure it to the real estate. And in fact, that would be unfair to the United States
So,
of America.
so you got a judgment on the note, but the court refused to foreclose.
Correct.
Correct.
And I just want to go back real quick. There is a case on point as far as the allowing of a duplicate record with only a notary acknowledgement, and that is, and it's in my brief, it's SVJV 2005 v. Ream, and the facts are almost identical, except in that case, the court actually accepted the duplicate, and then the appellate case was about not accepting it. But the court stated that it didn't need to be a certified document, that each exhibit that has a page consisting of an acknowledgement of a notary is self-authenticating, and they affirmed the judge's decision to accept that self-authenticated copy acknowledgement as a valid document.
And did they accept that as a matter of law or within the court's discretion?
I can't say for sure.
I just wondered in the actual case that they say it wasn't an abuse of the court's discretion. You don't remember that?
Not off the top of my head.
That's okay.
I will say though, in researching this, it is incredibly rare for courts to not accept copies of mortgages, that the arguments tend to be against accepting the copies, not denying the copy and then having to argue it the other way.
Thank you.
Thank you.
May it please the court, Attorney Joseph Salzgeber on behalf of the defendants, David Myers. In this case, we're arguing that the trial court did not err or abuse its discretion by excluding what was a non-original, uncertified copy of the alleged mortgage agreement marked Plaintiff's Exhibit 6 from admission at trial, where that document did not satisfy the requirement for admissions of documentary exhibits. It was undisputed that this was not the original mortgage document signed by David A. Myers. This was not a certified copy of that mortgage agreement, nor was it disputed that there was no testimony by the sole witness of the U.S.D.A., the United States of America, Mr. John Runyon, that he had ever compared Plaintiff's Exhibit 6 to the original recorded mortgage agreement, which was in possession of the Medina County Recorder's Office, only a block away from this courthouse.
Counsel, I'm going to ask you, Judge Hart had posited this question to opposing counsel regarding whether or not this is an error at law or it's an abuse of discretion standard on review, or a combination of things.
I think it's admission or exclusion of evidence is an abuse of discretion matter, but the legal issue is, it's a little tangled, because the legal issue is whether or not this is something that can come in, and if it's not properly authenticated either by being an original certified copy or at least a duplicate that's been compared by the witness who's testifying about it. And in this case, none of those three legal requirements were met, so I think it was, the court was well within its discretion to exclude this Plaintiff's Exhibit 6 insofar as it was a simple matter of asking for a recess, and you could go down to the recorder's office and get a certified copy to satisfy the requirement if your witness can't testify that he actually compared the two documents.
I think the argument on the other side is we could have had that been raised by counsel for Mr. Myers at the time we sought to have it admitted.
And I think that's implicit in the objection. We're saying hearsay, the objection dealt with hearsay, the fact that it wasn't an original or certified copy, and Mr. Myers had in his answer to this complaint that he denied the mortgage, the allegations with respect to the mortgage being in place. So the plaintiff knew that that was an issue, that they would have to demonstrate that there was in fact a valid mortgage, and they simply did not get either an original or a certified copy.
So you're saying in the answer, making sure I understand.
So, well, I'm saying in the answer, it was an issue that was raised due to the denial in the answer, and then implicit in the objection. You're saying hearsay, it's not an original or authenticated copy. Well, you're raising the question of the authenticity when you're making that objection.
And during cross-examination of the bank's witness, it was asked of him, did you compare this document to the original on file at the clerk's office?
And he did not, yes.
What I'm asking is that question was asked.
I believe so. I believe so. And we have some analogous cases. Probably the closest analogous case is out of the First District, Bank of America versus Smith, whereas in this case, the plaintiff appellee bank and its counsel failed to introduce an authenticated copy of a mortgage document in a foreclosure case. They instead attempted to introduce an uncertified photocopy of the purported mortgage agreement. There was no sworn affidavit or testimony as to the authenticity of that uncertified photocopy. Therefore, the First District Court of Appeals sustained the assignment of error on the part of the debtor, where the uncertified photocopy, which was not otherwise authenticated, was not admissible and was improperly before the court. Similarly, this court in 2014 in PNC Bank versus West reversed a trial court decision granting summary judgment for a plaintiff appellee bank in a foreclosure case where the trial court erred in considering non-original documents attached to the affidavit. Well, those documents were not certified. Self-authenticating copies under 902 subsection 4, and the affiant did not testify that she compared the photocopied documents to the originals as required under Evidence Rule 902 subsection 1 and Evidence Rule 105 for admission. In this particular case, although there were objections, there was no transcript filed, so Judge Collier, in considering the objections, had to take the facts found by the magistrate to be true and accurate. And he determined that in this case, the plaintiff did not present an original acknowledged document. That Rule 1002 requires an original writing except as otherwise provided in the evidence rules of the ORC, which would refer to a certified copy if one had been required. The document produced by plaintiff at trial in this case consisted of copies of an acknowledged document. Judge Collier determined that the best evidence rule still applies to documents sought to be admitted under Evidence Rule 9028 because Evidence Rule 9028 does not specifically dispense with the original writing requirement. In short, if this had been an original document or a certified copy or a duplicate that had actually been compared by the witness, John Runyon, to the document in possession of the Medina County Recorder's Office, then it would be admissible. The fact that it was not means that it was not an abuse of discretion on the part of the magistrate in this case to exclude that plaintiff's Exhibit 6. We would ask that this court therefore affirm the decision of the trial court below.
Thank you, counsel. You have 5 minutes remaining.
I just want to touch on a couple quick points. One, you mentioned the cross-examination piece. At no point did Bruce Hall question my witness, John Runyon, during cross-examination about the mortgage. The transcript shows that he asked him many questions about the promissory note, the reamortization, et cetera, but the mortgage was never brought up. The objection, the hearsay and certified copy objection happened at the admittance of evidence, which happened at the very end of the trial.
Well, let me ask you about that.
Yes.
Now, I know you have, or at least you're saying you have a transcript before us now.
Yes,
But he's saying, the appellee is saying there's no transcript before the trial court on the objection.
that's true. The
So-
transcript was filed with my brief with the appellate court.
So what are we to do with that? Because the trial judge would have no idea what objections were made and what the basis of that would be.
The only thing I can say is that the magistrate's decision addressed specifically the fact that the mortgage shouldn't be accepted because of the evidential 9024, the non-certified copy. My answer to that was, please read a little farther down on 9028, it was an acknowledged copy, so at the time, I didn't believe that the transcript was necessarily going to be necessary because I believed that that self-authenticating rule would, in fact, change the magistrate's decision. Judge Collier, in his order, was the first time I heard about the objection as to the duplicate rather than the hearsay or certified copy. So as this case progressed, each decision added another layer of reasons to exclude this mortgage, and only then did I realize I need to argue all of it together in one whole piece. The other interesting part in this is this was actually the second bench trial in this same foreclosure case. The first bench trial, well, let me back up, there was actually, at the very beginning, a motion for summary judgment issued way back where my client, John Runyon, did in fact say that he compared the copy of the mortgage that was attached to the complaint to the original and authenticated it. However, this court does not rule on motions for summary judgment when there's been an answer, so we proceeded to bench trial and on and on. So from the very beginning, there wasn't necessarily a question to that authenticity because I did have that affidavit. Now, that wasn't presented in September during the bench trial, but
Well, thank you.
also, lastly, had these issues popped up during the bench trial, I absolutely would have recessed to go the block down the street. And we had actually recessed multiple times through that trial just because there were some other criminal things going on. So it wouldn't have been a big deal for me to have gotten that had I realized that that was going to be as big of a problem as it was. Thank you.
Thank you. The court will take the matter under advisement and issue a written opinion that will be sent to both sides, as well as released on our website. So we'll give you the opportunity to read it in both ways.